Hello and welcome to LiveLaw. My name is Padmakshi Sharma and today we will be talking all about the recent controversy where the Delhi Chief Minister Arvind Kejriwal was not allowed to travel to Singapore. You must be aware that Kejriwal was supposed to attend the World Cities Summit in Singapore. However, the Lieutenant Governor or the LG of Delhi, LK Saxena, refused to permit him to travel. The LG's refusal to grant clearance for the CM's visit has opened up a legal controversy. Delhi's Transport Minister Kejriwal has now approached the Delhi High Court seeking broader guidelines for permissions required by elected ministers to travel abroad. Now you must be wondering why the CM or any other minister for that matter needs permission from the central government to travel abroad. Here comes the concept of political clearances in India. Well, it was in 1982 when the Cabinet Secretariat issued guidelines regarding foreign travel of ministers of state government and union territories and state government officials. These guidelines stated that foreign visits by members of state governments in their official capacity would require clearances from the Ministry of External Affairs, the Ministry of Home Affairs, the Ministry of Finance, and the Central Administrative Ministry. Now, why was this done? Well, the requirement of political clearance was inserted to ensure that there was no objection from a political angle to the visit of a bureaucrat or an official to a foreign country, keeping in view the objectives of the visit and other such factors. In 2004, the guidelines were modified to the extent that further approval of the Prime Minister's office before an official visit would also be required. And in 2010, the Cabinet Secretariat enlarged the scope of political clearances and even private visits of ministers in state governments were included in the guidelines. This is not the first time travel clearances to various ministers of the government of Delhi have been denied. The Chief Minister was previously denied permission to attend the C40 World Mayor Summit in Copenhagen in 2019. In fact, the Transport Minister, who is the petitioner in the current writ petition filed before the Delhi High Court, Kejriwal, was also denied to travel to London on the invitation of Transport for London. So this is why he is also an affected party in the matter. In this matter too, when CM Kejriwal received an invitation to participate in the World Cities Summit, he applied for a political clearance for his official visit. According to Kejriwal, the Ministry of External Affairs failed to respond to the application for the visit. The CM then addressed a letter to the Prime Minister highlighting the delay in clearing the Singapore visit and requested expedited clearances. Meanwhile, the LG wrote back to the CM stating that the visit to Singapore was not advisable on the grounds that the World City Summit was a conference for city mayors and therefore unsuitable for the Chief Minister's office to attend. Further, he stated that the summit was on urban governance, and in any case, the government of Delhi did not have exclusive domain over urban governance in Delhi. It is after this that Kejriwal approached the Delhi High Court seeking broader guidelines on the issue. Gehlot submitted that the requirement of political clearances from the Ministry of External Affairs for personal foreign visits of state government ministers violates the minister's right to privacy and also the dignity of the constitutional office. He has also submitted that the advice of the LG against the proposed Singapore visit was beyond the jurisdiction of his office's authority and therefore it should be set aside. Further, he said that the use of delay on part of the ministry to deny clearances for official foreign visits was itself an arbitrary non-exercise of power, and the same has to be corrected by way of appropriate guidelines. It is interesting to note that a similar issue was faced by Supreme Court and High Court judges as well. They were also required to obtain political clearances for any foreign visits, and this was challenged before the Delhi High Court in April this year. In that case, the petitioner had submitted that the guidelines in question not only violated the right to privacy of judges, but also, in a sense, degraded and diminished the high office that they held. Solicitor General of India, Tushar Mehta, appearing for the centre in that case, had submitted that the information concerning judges traveling abroad was required even when they were on a private visit, so that in case of any emergency, they can be extended some sort of assistance. To this, the Delhi High Court had said that if any Indian citizen, which also includes a judge, is caught in a crisis, Indian embassies and missions are duty bound to extend assistance anyway. So requiring information of travel of judges was simply not necessary. After that judgment, it would be quite interesting to see what the High Court will hold in the case of state ministers travelling abroad. The matter is now listed again for 22nd August 2022. And while the court gives its opinions on the matter, I want to know your opinions on the same. Do you think that state government ministers should be required political clearances from the centre for official as well as personal visits? Do you agree with the decision of the Delhi High Court striking down the requirement of judges obtaining political clearances for any foreign visit from the Ministry of External Affairs? Well, let me know what your comments on the issue are by commenting below, and if you wish to see similar content, subscribe to our channel.